So far we've been talking about purposive interpretation in the context of EU law. I want to turn at this point to consider purposive interpretation outside the context of EU law. In other words, in those areas which don't raise European legal issues. And I want to make major reference here to Lord Bingham in a case called Quintervel and Secretary of State for Health, because I think this is again an important case that helps us to understand the dynamics of contemporary practice. Now, Lord Bingham in this case suggested that as far as contemporary judicial practice is concerned, the pendulum has swung towards purposive methods of construction, in other words, away from literal methods of instruction. Now, Lord Bingham goes on to say that these interpretative tendencies have been encouraged by, quote, the teleological end-directed approach of European community jurisprudence and the influence of European legal culture generally. But how purposive should a court be? Lord Bingham argued that, quote, the degree of liberality permitted is influenced by context, e.g., social welfare legislation and tax statutes may have to be approached somewhat differently than other areas of law as far as this question of the degree of liberality, the degree to which a court can be purposive is concerned. So, we might think that the extent to which a court will use a purposive method of interpretation relates to the law under construction, the context. This point appears to be confirmed by the main authorities. So, in this case that we're concerned with, Quintervel, an important earlier case, Royal College of Nursing and the DHSS, we were concerned with advances in medical technology and techniques. The pressing question, could the relevant statutes be interpreted purposefully so they covered new concerns? In Royal College of Nursing and the DHSS, Lord Wilberforce, who actually was dissenting on this point, pointed out that the starting point is to, quote, have regard to the state of affairs existing and known by Parliament to be existing at the time that the Act became law. The court then has to consider whether a fresh set of facts falls within parliamentary intention. Lord Wilberforce proposed a new test. A new set of facts could be held to fall within Parliament's intention if the facts cover what he called the same genus of facts as those to which the expressed policy had been or has been formulated. This is a rule of thumb. Further guidance can be obtained by reference to, quote, the nature of the enactment and the strictness or otherwise of the words in which it has been expressed. The judges would thus be less willing to extend the meaning of a statute if it is clear that the Act in question was designed to be restrictive or circumscribed in its operation rather than liberal or permissive. Extending the meaning of an Act would become even less permissible if the subject matter is different in kind or dimension from that for which the legislation was passed. The key point is that judges cannot fill gaps. Remember here, we're not concerned with European Union law, we're also not concerned with European human rights law. We are attempting to determine the acceptable degree of purposive interpretation outside of those areas of law. Lord Bingham in Quintervel provided an updating of Lord Wilberforce's argument in Royal College of Nursing and the DHSS that the court could not fill in gaps. He pointed out that a narrow adherence to the literal rule may even lead to the frustration of the will of Parliament or the intention of Parliament in legislating, because undue concentration on the minutiae of the enactment may lead the court to neglect the purpose which Parliament intended to achieve when it enacted the statute. Context, for Lord Bingham as for Lord Wilberforce, is the guide. Quote, the controversial provisions should be read in the context of the statute as a whole, and the statute as a whole should be read in the historical context of the situation which led to its enactment.